Hi, everybody. My name is Victoria Lenton. Today we're going to be speaking about immigration law for criminal lawyers. Just by way of my background, I am an accredited specialist in immigration law, one of only 6 in Queensland. I'm the principal solicitor of Lenton Migration Law. Here with me today is Nick Dorr.
Hello, everyone. My name is Nick Dorr. I'm a managing principal of Fisher Dorr Lawyers. I'm an accredited specialist in criminal law. I've been practicing in criminal law now since 2000, so whatever year you're in now, minus that off that and get it back to 2000. I've been admitted since the start of 2002. I'm very excited to be here today to discuss what I think is a really important issue that a lot of criminal lawyers sometimes not necessarily neglect, but can overlook in the preparation of matters, particularly in the way we live our lives now in relation to immigration and the global population that's in Australia now.
Yeah, this is a topic for me that's really important to me. I've worked with Nick before as a consultant for Fisher Dorr Lawyers, working in this space, and I specialise in my firm in immigration matters where visa holders have criminal charges and criminal convictions. This is not a very common area of immigration law. There aren't a lot of lawyers in Queensland or in Australia who specialise in this, and it's incredibly important. So in terms of why it's important, I think probably if you're a criminal lawyer, you've already seen that you might have a person who has a visa where you go through the criminal law process, and that's not the end of it. At the end of the criminal law process, if there's a conviction, there may well then be another process that follows. And that process that follows is often even more life-changing potentially than a criminal conviction, because it'll affect the rest of their life, basically, in terms of where they live.
Exactly. But identifying at an early stage too is really important, because it's like any other area of law that comes across your desk. You're used to doing criminal law, but again, you've got to keep your eye out for PIPA matters, for personal injury matters. So if the person was the passenger in an unlawful use of a motor vehicle and the car crashes, that person may have a motor accident claim. You've got to identify these sorts of issues, and it's not uncommon in the criminal law space for that not to be identified, and then the problems happen 2 or 3 years down the track. And with what we'll discuss later, particularly in relation to how you negotiate the charges, the submissions you make on behalf of your client during those proceedings, and even the factual basis. And I guess as silly as this sounds, because I'm sure a lot of people listening are very experienced lawyers, is the importance of the checklist, of actually having, when you see that initial client, identifying, like you would with anything. Do you have a blue card? Do you work with children? Do you have another professional organisation, law society, APRA? Just having that checklist, just including that checklist with a really simple yes or no. And Victoria can vouch this. I mean, sometimes the clients themselves don't actually know whether they are a citizen or not. And we've had matters where they've said, yes, I'm an Australian citizen, found out literally during the sentence that they're not actually an Australian citizen. So identifying it isn't a rude issue. I ask every single client. Some look like you've got 2 heads, but it's just better to know. So
absolutely.
As a starting point with any matter, you should always ask that question.
What really led me to create this session is exactly that. I was doing these for the last 7 years. I've been doing 501. They're called matters, character cancellation matters, and consistently what was coming up for me is I could see that there was either missed opportunities at the criminal law stage, or actions taken or decisions made in relation to the criminal law matter that had really enormous implications at the immigration stage. And what that led me to do, particularly once I came in and did some work with Nick at Fisher Dorr Lawyers, is to start to see how crucial that criminal law stage is for these matters. And so there is so much that you guys as experienced criminal lawyers can do that can set your clients up for success at this later stage. And so in terms of how the session is going to be structured, where basically there's 2 parts to it. The first part is really going to be me talking to you and explaining exactly what the 501 power or the character power, what they look like. So I think having that really kind of clear understanding of what the migration legislation is and what's available and what that process will look like, that's really important as a base thing. The second part of the session is going to be much more practical. And the idea is to really talk about a number of takeaways for you as criminal lawyers that you can take away, take to your practice. As Nick said, straight away, the first step is always to identify, is your client a visa holder? Does this affect them at all? And then if you've identified that in your intake, what things should you be looking out for? And what things you as a lawyer, your juniors in your team, everyone, to make sure you're doing that. It's going to be super practical, that second part of the session. The idea is it's not theoretical, it's what you can do in practice. I've got checklists that I will share that the QLS can share with you. So hopefully it's going to be really beneficial. So as I said, we're going to do the first part, which is the lecture part where I talk about exactly what this power looks like. And then we will move into the practical session where Nick and I will have a really good conversation about what this looks like in practice. Okay, so as Nick and I said, the first half of the session is really going to be more of a lecture. So it'll just be me talking to you now about giving you really an overview of the immigration processes that your clients might be facing after they move out of the criminal law space and into the immigration law space. So we do this, the second half of the session is really going to be very practically focused. It will be a conversation with Nick talking about practice issues and how really criminal lawyers can things that they can apply in their everyday practice that is going to ensure that you're giving the best possible service to your visa holding clients. But before we move into that space, I think it's really important that as criminal lawyers, you have a really clear understanding of what is the visa cancellation powers that exist and how might your clients, how's this going to interact with you? So I'm going to do a bit of an overview of the visa cancellation powers. We'll talk about the consequences of visa cancellation, a little bit about the actual legislative framework, and then we move into part 2, where it'll be the conversation with me and Nick about issues for you as in practice as criminal lawyers. All right, so we're going to start with a little bit of a very quick history of immigration law in Australia. Basically one really important thing to understand as a non-immigration lawyer is that Australia has what we call a universal visa system. And that universal visa system was introduced in 1994, so quite a long time ago. What that means, universal visa system, is that every single person in Australia either has citizenship, Australian citizenship, has a visa, or doesn't have a visa. If they don't have a visa, they fall into a category of person that is under the legislation called an unlawful non-citizen. So everyone's either an Australian citizen, a visa holder, or an unlawful non-citizen. The category of unlawful non-citizen is really important because under the Migration Act, if a person is an unlawful non-citizen, they are subject to immigration detention, so detention in an immigration detention centre, and removal from Australia as soon as practicable. That's under Section 198 of the Migration Act. So that introduction of the universal visa system in 1994 was the point at which the power to cancel on character grounds in Section 501 was introduced. So that 501 power, so you'll hear me talking about 501 cancellations, that is the key mechanism used by the Australian government now to address visa holders in Australia with a criminal record. Just a quick note on terminology, you'll hear me use the words removal, whereas you might have more commonly use in day-to-day speech the word deportation. So deportation is not the technical word that we use in immigration law. There is a deportation power, in fact, under the Migration Act. It's under Section 200 of the Migration Act. So it's an entirely different power. That power has been in the Act since the introduction of the Migration Act in 1958. And it was before 1994 was the power that was used to deport people. It is quite different than the 501 power, most importantly because it only applies to people who've been in Australia less than 10 years, and that distinction no longer applies. So the 501 power can be used for a person who's been here literally from birth. So you'll hear me talk about removal rather than deportation. So prior to 1994, we didn't have that universal visa system. There was a series of permits and other things, which are a little bit complicated, but very important. If your visa gets cancelled, you move from having a visa and having a valid visa to stay in Australia to being an unlawful non-citizen, and you're going to be detained and removed from the country. So as I said, that Section 501 cancellation power isn't limited to people who've been in Australia for less than 10 years. It applies to all visa holders in Australia, whether they're temporary or permanent, regardless of how long they've lived in Australia. That Section 501 power, since its introduction, has been continually expanded. They have, what I mean by that is they've lowered the threshold when the power applies. So when a person fails the character test and the power can be exercised and the visa cancelled. They've introduced something called the mandatory cancellation power under Section 501(3)(a), which we will spend a lot of time talking about because that's the main one that you'll see used. And they've made changes to the ministerial direction that guides the discretionary element of decision-making in visa cancellations. There's also been use of other powers. So there's something called Section 1161E, which is a general visa cancellation power, and that relates to where a person is a risk to the health, safety and good order of the Australian community. And that has sometimes been used for people who've just been charged with a crime rather than actually convicted. Part of the reason we're talking about this is that the consequences of visa cancellation are really significant. So obviously the consequences of a person being charged and convicted of a crime are incredibly important to that person and life-changing. The secondary, the flow-on effect consequence of then going through a visa cancellation process is or can be just as devastating or more so, because it will impact the rest of that person's life, but not just their life, but the life of all of their family. So if you are cancelled, you no longer have a visa, you're going to be put into immigration detention and you're going to be removed from Australia as soon as practicable. If you're owed international obligations, so for example, protection obligations under the Refugees Convention, and there are a few other types of complementary protection obligations, you won't be removed because that would breach our international obligations. Previously, you would be subject to indefinite detention. Now, post the High Court case of NZYQ, you might be given an indefinite bridging visa. You will be prevented from applying for any other visa while you remain in Australia, with the exception of a subclass 866 protection visa. That subclass 866 protection visa can also be refused on criminal conviction grounds, so that's not necessarily a good answer. It refuses any other pending visa applications, and it cancels any other visa that you might hold at that time. Importantly, a 501 cancellation is not going to result in consequential cancellation of family members, although a Section 1161E that I mentioned before would result in consequential cancellation for everybody else. Very significantly are the exclusion periods. For a 1161E decision, you're going to be excluded for 3 years, but for a 501 decision, you are permanently excluded. So if your visa is cancelled under Section 501 and you're removed from the country, and that matter is finally resolved, there's no more appeals, that's permanent. You will never be allowed back into Australia. So this is what I mean by sort of the level of consequence here is really high. I don't want to make this too complicated because there's only so much as criminal lawyers that you need to really be familiar with. So the PowerPoints here are going to have a lot of information that you're really welcome to review carefully. But I will kind of go through things in a kind of light way and focus on the things I think are most important. But there are more than one 501 cancellation powers. I think this is important to know. The two main ones I think you need to be aware of, because they're kind of the critical different ones, is 501(2) and 501(3)(a). They're both, so 501(2) is your kind of base one. This is the discretionary power to cancel a person's visa if the decision maker is satisfied that the visa holder does not pass a character test. So, and the person gets natural justice. So they get the opportunity to comment before the decision to cancel is made. Then you have section 501(3)(a). This is the mandatory cancellation power that I mentioned earlier. This is a power that's not always available, but it will, where it meets the relevant threshold, it must happen. So the person's visa gets cancelled. The person's visa gets cancelled, and then they get invited to request revocation of the cancellation. And they get the opportunity to make representations about that revocation request. Those are the two critical ones. The other ones I've mentioned here, 501(3), 501(b)(2), and 501(ba)(2), those are ministerial powers. So this is powers that are exercised by the minister personally, so the Minister for Immigration. I won't go through them in detail. They are generally not the first port of call. Generally, a client will be going through those if they've already gone through a 501(2) or 501(3)(a) process and have been successful at the tribunal stage or the ART stage, which we'll go through in more detail in a bit. But really important to understand the difference between 501(2) and 501(3)(a). So we'll go through that now. So both 501(2) and 501(3)(a) have an objective and subjective part. So there's the threshold, is do they meet the threshold for the exercise of the test? So does the person fail the character test in 501(2)? And if so, should the decision maker exercise the discretion to cancel? In the case of 501(3)(a), it's does the person fail the character test on certain grounds, and the person is serving a sentence of imprisonment at the time, then the mandatory cancellation power must be used. And then the discretionary element, the subjective part, will be should the decision maker exercise the power to revoke that visa cancellation. So in terms of the key differences between that discretionary 501(2) and the mandatory 501(3)(a) visa cancellations, the critical part relates to the timing of the visa cancellation. So in the 501(2) space, the visa cancellation happens at the end of the natural justice process. The person gets a notice of intention to consider cancellation. They get to comment on that and make submissions as to why the visa shouldn't be cancelled. And then the decision maker makes a decision at the end of the process. In 501(3)(a), that gets reversed. The cancellation happens at the start of the process. They get notified of the cancellation and invited to apply for revocation. And then the decision maker considers, you're able to make submissions and provide supporting evidence as to why the cancellation should be revoked. And then the decision maker makes a decision on whether or not to revoke the cancellation at the end of the process. That change of timing of when the cancellation happens has some pretty significant impacts on the client. So, for example, the whereabouts of the person during the decision-making process. So for the 501(2) case, the person is going to have a visa throughout that process up until a decision to cancel is made at the end of the process. So that means that if they've been released from prison, they go into the community throughout that process. In contrast, 501(3)(a), the cancellation happens at the beginning of the process. So the visa's cancelled. Because the visa's cancelled, they no longer have a visa, which makes them an unlawful non-citizen, which means that they're subject to immigration detention. So once they're released from prison, they go into immigration detention, which is where they stay throughout the decision-making process. Those differences are really crucial. Obviously, a person in the community has, the opportunity to demonstrate their safety in the community. They have the access to much better resources. They have freedom of movement, all of those things. Whereas a person in immigration detention is, necessarily very restricted about their ability to respond to the notice in the same way. So it's pretty important which category they fall within. It's important to understand, but from the purpose of of a criminal lawyer, though, you're going to get clients who might be subject to either. So either 501(2) or 501(3)(a). The critical question is, do they fail the character test always? That character test is defined in section 501(6). You can see on the PowerPoint that there are a range of ways that a person can fail the character test. I won't go through all of them, but I'll just highlight the two bold ones, which are the main ones that come up. So the first one is that they have a substantial criminal record. So a substantial criminal record is defined as a person who's been sentenced to a single term of imprisonment of 12 months or more, so a head sentence of 12 months, or multiple terms of imprisonment that add up to 12 months. Now, importantly, it doesn't matter whether or not they actually serve any time in prison. So a wholly suspended sentence of 12 months will still mean that that person is subject to, will fail the character test and will go through a visa cancellation process. The other one to mention is that have they been convicted of any sexually based offence involving a child? And that's regardless of the sentence. So those are the two ones that you will more likely come across. I'll just briefly mention one that I think is very interesting, which is B, which is, do you have an association with a group involved in criminal conduct, like a gang? Really important to understand that doesn't have to involve any direct criminal activity on your part. It could literally be an association through a relative. An innocent association, means that the discretion is unlikely to be exercised, but it can still make you fail a character test, which I think is very interesting. So substantial criminal record in 501(6) is defined in 501(7), so you can see there. And really importantly, that it includes suspended sentences, even entirely suspended sentences. So just to talk a little bit more about the mandatory cancellation power. This is the very difficult power, and this is more often than not where most of my cases come from, and where I think as criminal lawyers you're most likely to see cases that are going to fall within this category. So to exercise this power, a few conditions have to be met. So the first one is that the person has to fail the character test on the basis of a substantial criminal record, but only where there's one head sentence of 12 months or more. So in cases where a client has multiple sentences that add up to 12 months, but no single sentence that is 12 months, they won't fall within the 501(3)(a) power. Or they have to have been convicted of a sexually based offence involving a child. So it's 12-month head sentence or a sexually based offence involving a child, regardless of the length of sentence. And they have to be serving a sentence of imprisonment. That's really important. So they actually have to be in prison. So if they're in prison and they fail the character test with a head sentence of 12 months or more, or a sexually based offence involving a child, they are going to be subject to the 501(3)(a) mandatory power, and their visa will be cancelled, and they then will go through the revocation process. This can also come up in sort of unexpected situations. So it may be that the client, your client is going to prison for a 3-month sentence of prison. So not 12 months. The conviction and sentence was 3 months, and they're in prison. If in their previous history they have a 12-month sentence, even if they never went to prison for that sentence, they're going to be subject to 501(3)(a) because whether or not they fail the character test considers their entirety of their criminal record, not what they're currently in prison for. So it can come up in cases where you may not expect it. Also worth mentioning is the situation that can happen where a client is convicted of a crime with a head sentence of 12 months, and serves time in prison, and that visa gets cancelled under 501(3)(a), but then the conviction gets overturned through appeal. In that case, the cancellation stands and they still have to go through the 501(3)(a) process, even though that person might be released from prison. They will go into immigration detention until we're able to get that the cancellation revoked. Generally, it will get revoked, but it's not as automatic a process as you would think. So it's still a bit of a process. So both 501(2) visa cancellation and 501(3)(a), you have the threshold of exercise of the power, and then you have a discretionary element. So for 501(2) cancellations, the discretion is whether or not the decision maker should cancel the visa. And for 501(3)(a), it's whether or not the decision maker should revoke the visa cancellation. In both cases, that exercise of that discretion is governed by something called Ministerial Direction 110. So this is a direction made by the Minister for Immigration under the Migration Act, under Section 499, and allows the minister to tell decision makers, this is how you must exercise this power. It has a status higher than policy. It must be applied in making these decisions by both the departmental delegate decision maker as well as the administrative review tribunal decision maker. So the discretionary consideration to cancel or to revoke the visa cancellation is a subjective process. The direction sets out 5 primary considerations. The first one is the protection of the Australian community from criminal or other serious conduct, and that considers both the nature and seriousness of the crime and the likelihood of reoffending. You've got whether or not the conduct engaged in constitutes family violence, which is obviously considered very serious, the strength, nature and duration of ties of the person to the Australian community, the best interests of any minor children in Australia, and the expectations of the Australian community. That last one is what we call a deemed provision, which basically means that it will always be considered negative to the person. So if they've committed a crime, the expectation under the direction is that they will have their visa cancelled. So what you can see from those 5 primary considerations is generally you're going to have 3 primary considerations that more likely than not are going to weigh against the person. And then potentially, depending on the circumstances of the case, you're going to have 2 primary considerations that may be in their favour in terms of weighing against visa cancellation. So that's strength, nature and duration of ties to Australia and the best interests of any children. The decision maker can also consider other relevant considerations, although these will not be considered primary. So that can be legal consequences of the decision. So, are they owed protection obligations? Are they going to be indefinitely in the community on a bridging visa? Are there any impediments to their removal overseas? Impact on victims, impact on Australian business interests, things like that. The visa holder, I think it's important to understand. So that's basically the legislation and the visa cancellation power that's available. From a practice perspective for you guys as criminal lawyers, I think it's important that you understand what is the step-by-step of the process. What is it going to look like once the person moves out of the criminal conviction and then through that process moving forward into the immigration space? So the first step is obviously you've got a visa holder and they're convicted of a crime and they're serving a sentence of imprisonment that brings them within the scope of 501(3)(a). So that means that they have a head sentence of 12 months or a child sex offence, and they are in prison serving a sentence. In that case, the decision maker cancels the visa, so the client will then receive in prison a notice of visa cancellation. It will always be in prison because the power can only be exercised if the person is in prison. The department sends that notification, and that invitation invites them to request revocation of the decision to cancel. The visa holder must respond to that notice within 28 days. And must request revocation. That is a critical deadline. If that deadline is not met, there is nothing that can be done. There's no extensions possible. It doesn't really matter what that person's circumstance is in. The person then has time. They have to request extensions generally, but they have time then to make submissions, legal submissions as to why the cancellation should be revoked, and provide supporting evidence in support of those submissions. The decision maker, the Department of Home Affairs, receives all of that information, and they then make a decision on whether or not to revoke the visa cancellation. As I'll talk about in a moment, you'll see that most of the time at the departmental level, more than 80%, the decision will be no, that they won't revoke. The person will then get a notice from the department telling them that the department has made a decision not to revoke the visa cancellation. In that case, the client can then apply for merits review of that decision not to revoke at the Administrative Review Tribunal. That is under the ART's general jurisdiction. That's different than general immigration decisions, which get appealed to the Migration and Review Division of the ART. Really importantly is that expedited ART arrangements apply. So the decision will be made 84 days from the date of the notification to cancel, so very, very quickly. And then throughout that process, the client's going to be in prison. And then once they finish their sentence of imprisonment, they're going to move into immigration detention unless they request removal. So that's where they'll be throughout that process. So that was a very, very quick explanation of the legislative framework and the visa cancellation powers. Where now I'm going to sit down with Nick and we're going to have kind of a really, hopefully really useful conversation where we talk about what are the key takeaways for criminal lawyers in applying this understanding of the consequences of criminal matters for visa holders in your practice, and what you can do as a criminal lawyer to make sure you're providing the best possible legal services to your client group. Now we're going to move into talking the more practical part of the session, which is really talking about now that we've gone across all of the legislation and the rules and things that can happen in certain circumstances for visa holders who have a criminal conviction. Now we're going to really talk about the practical part for criminal lawyers, which is what we want you to take away from this session. And really understand about this process and how you can apply it to your practice. So basically the first thing I want to make sure everyone understands is that prospects of success in a visa cancellation process where a visa holder has a criminal conviction that triggers this process. Exactly. It's really difficult for us to win. Yeah.
And that's a consideration of it. Obviously, it always becomes a live issue once you're aware of the visa status and the visa is going to be an issue. Because obviously with the 12-month rule, if we call it the 12-month rule, as I like to call it, if there's no chance of getting below that, regardless.
And sometimes it's not.
And sometimes there's not. You're just not going to get less than that for some pretty significant charges. Yeah. It's a matter then of, and we've done this, it's been a consideration in a lot of matters we've done, particularly in relation to importation charges, where people have come in on the holiday visa, brought in drugs, and you go, well, look, you can get bail and sit in immigration detention for 2 years. Yeah. We can sit in jail for 2, and we go to court and say, you're going to get deported. Yeah. So being realistic with clients in relation to that, and that being the issue, that sort of expectation management at the end of it all is something that's really important. If you're not having that conversation at the start, like in criminal law, again, it's not something that's just when it comes to migration issues, but it's just expectation management in general. Yeah. It's just good practice to have that understanding, work that, and be able to say, these are going to be your difficulties in the long run, and decisions need to be made. You may not want to spend $200,000 on a trial. Yeah. You may want to spend $20,000 on a sentence, try to get as low as possible, because either way, you're not staying in Australia.
Exactly.
And you're getting conviction for, or the possibility of conviction for this. So what does it matter?
That's one of the things we'll talk about in more detail soon is it's about how does an understanding of the immigration law consequences impact your legal strategy moving forward. 100%. Yeah. And different cases will be different on this. Yes. So at the departmental level, so there's 2 stages, as we've spoken about. There's the initial decision by the department, and then we know the statistics show that more than 80% of cases at that initial departmental level, we're going to get a cancellation or we're going to be unsuccessful in getting the cancellation revoked. there is a much higher chance of success at the administrative review tribunal level.
Yep.
But even then, there are certain types of cases where it is close to impossible to win. And as Nick said, it's really different depending on the person's background and circumstances. So a person here on a student visa, there is almost no chance to be successful.
Correct.
And, that is going to inform their decisions around how they spend their money. But a person who is a permanent resident who has been here most of their lives and has extensive family, they obviously are going to have a higher chance, but that is balanced against the nature and seriousness of their crime.
Yes.
So, but really important to know, it's hard to win. And so everything you do, if it's a client who is going to be really motivated to stay here, having a think about how these things work in your part of the process is going to be important.
And sometimes it works the other way too, in the sense of if the person has got nothing to lose because they're going to be deported, sometimes they go, well, let's plead not guilty and run a trial and take that risk. Because if the only way from staying in Australia is being found not guilty,
let's do it.
Let's just do it.
Yeah, exactly.
Let's just do it. That's correct. Yeah.
Yeah. The next thing to make sure everybody understands is about timing in these cases. So, and this isn't in the immigration space, so post the criminal conviction. The department will take a really long time at the departmental decision stage. Yes. So this is when the person, if it's a mandatory cancellation under 5013A, the person's visa will be cancelled. That may take place at the beginning of their criminal sentence in prison, or it may be towards the end. But either way, that process is going to take a long time. Yes. The department can take 6 months, 2 years, even longer to make a decision in that. The next part, once they make a decision, and as we know, most of them are going to be negative, the tribunal stage, where they have much more higher chance of success, that is going to be incredibly rapid. There is an expedited process in place where you only have 9 days from the date of decision to appeal to the tribunal, and the tribunal is required to make a decision on the matter 84 days from the date the department makes the decision. So
it's 3 months.
Exactly, less than 3 months.
Less than 3 months, yeah.
So it is absolutely rapid, and there is literally no ability to extend it unless the client agrees to be removed overseas. So they voluntarily go home and they do the process outside of Australia. So that is really important to understand, more for immigration lawyers, but also for you guys, because that initial stage is at the departmental level. That's the stage where we're really gathering evidence, because we have time to gather evidence. And these cases, as we'll talk about soon, live and die on the quality of the supporting evidence that we can put forward. And I can't get what I need in 84 days. It's impossible. No. I regularly have taken on cases at that second stage, and it is so hard to be successful, and I pretty much have to kill myself to get the evidence together. It's really, really difficult. So we take our time at the departmental stage, which can be frustrating to clients, but we do that for a reason.
You do it. 100%.
And that's because we're doing it for their sake, because we know that's our opportunity to do it. So important to know. All right. As I said just now, these cases live and die on supporting evidence. This is really important for criminal lawyers. So for a few reasons, actually. So as I said, our gathering of comprehensive supporting evidence is most effectively done at the departmental stage because we have time. It is one of the difficulties at the moment with these types of matters is funding, so particularly for people who of lower means. So obviously legal aid exists for criminal matters for certain people. In those cases, that funding is available till the finalisation of the criminal matter, and then that funding ends. There is no legal aid funding for 501 matters. That can be super significant, particularly for, like, if I'm dealing with a pro bono client or a client who's super vulnerable, because we don't have any funding for reports. And things like forensic psychologist reports on risk of recidivism. Without a forensic psychologist report, it is almost impossible to be successful in these cases. And so if you've got a client, if you do legal aid work, for example, and you have a client who's on a visa, particularly highly vulnerable clients with things like schizophrenia or other kinds of significant mental illness or from refugee or trauma-related backgrounds, making sure that you put together really good supporting expert reports, if appropriate, obviously.
Yeah, that's right. I mean, and that's always a difficulty too, is obviously with the appropriate. Now, we're not trained. There's a certain amount of trauma informing that we have with some lawyers anyway.
Yeah.
But certainly being able to identify those issues. And look, if they're people of means, I always suggest they get a report because you never know what you're going to find. I mean, I'm not a psychologist. I can identify after a long time of doing this certain key traits that may lead to neurodiversity or something along those sorts of lines. But certainly from the perspective of you get one, $2,000 up to $5,000, $5,000, whatever it is, to just actually get it, particularly too in these matters, because like you said, you won't get it further down the track.
Yeah.
And look, there's nothing wrong with you, and there's nothing wrong with you.
Yeah.
You don't tend to report that's a glorified personal statement, but usually there is something, and most offending, I don't speak too generally, but a lot of offending that I've dealt with has come from some form of drug addiction as a result of childhood trauma, as a result of domestic violence, abuse, or something of that nature. That is usually an underlying reason. People don't just wake up in the morning and go, I'm going to be a bad bastard.
Most of my cases have something like that.
Of course
it's extremely rare for them not to.
Not to, that's right.
And I mean, you can tell me if I'm wrong, but like a forensic psychologist report that talks about are they likely to reoffend, are they rehabilitated, that's going to be useful for a sentence.
Of course it is. Yeah.
So it's what you get for that process, I can use at my process. And particularly if there's funding available and this is a client who can't privately fund it. So if they can privately fund it, if they haven't got it at the criminal stage, I get them to do it at the departmental stage of the immigration matter. But if this client can't fund it, then, and I do a lot of pro bono work in relation to people with severe disabilities, and most often that is people with schizophrenia who have a criminal law matter, who have a visa cancellation. Unless that's been done at the legal aid criminal stage. Yeah, that's right. Yeah, I can't get those reports, and therefore I won't have them.
No, and I mean, even just organising the material in such a way that, so in some of these matters where visas have been an issue, I've probably got more reference material than what I would in usual circumstances, and sometimes that can be obvious to certain judicial members who are sentencing, going, why am I reading 18 references? Well, they're not necessarily for you to read now. They're for someone to read further down the track, to have their material about the hardship, about how his kids are, how his family, how he or she's a good mum or dad.
Because having that stuff talked about in the sentencing transcript is so important.
Yeah, that's exactly it. But even again with the migration, with the cancellation, if you've got a problem with the grog, then go to the counselling.
Yes, and start that process as soon as possible.
If you've got a problem with the drugs, go to the urine test, so we can tender all that material. That even though it may sound like a long time, it's a portfolio of material that you want to be able to just give to the migration lawyer and go, this is what...
Yeah, this is where we're up to.
This is where we're up to. Now, obviously, I would imagine, and you can correct me if I'm wrong, but when you go to one of the reviews and they go, well, you attended 18 references and the magistrate or judge didn't mention one of them, it doesn't particularly matter.
No, that's
it was still
negative.
there. It's still there,
exactly.
And it's still material that these people, you're not producing now 6 months or 2 years later, references from Joe Bloggs who says, geez, this person's a good person. They go, well, that person actually said that 2 years ago. It still stands by it, even knowing that he was convicted of the offence and this was the penalty that was imposed.
And more likely than not, the sentencing judge is going to make reference to those things.
Because they have to. Because they have to.
It's tended. In their remarks. And what you
depends on what level they'll sometimes go to in relation to
but even
how much it sways them.
A reference to it in the transcript is really useful at my stage, because the decision maker at the department level and the tribunal member, they are put more weight on how the sentencing judge has evaluated the person's circumstances and their remorse and all of those things. So incredibly important. In terms of supporting evidence, I've said here that the most important evidence relates to a person's future risk of reoffending. Things like evidence of rehabilitation, We've already talked about a forensic psychologist report about the risk of recidivism. If a person has a psychiatric condition that's been undiagnosed, this is so common that particularly for highly vulnerable clients, again, this is more the legal aid cohort, is that they, because of their vulnerability, they've never really been exposed to any kind of health services until they get into the criminal justice system. And so this is the first opportunity maybe for them to get properly diagnosed, to get treatment of, you know, psychotic mental illness. Or,
attempt to get treatment,
exactly. And so if you have a client where you can see that there's potential, as you said, you now can
you can usually identify. I mean, and you're usually good with younger, particularly males, because that's predominantly criminal communities. But, you know, you can identify people who've got, you know, potential neurodiversity issues that you can go,
or like PTSD.
PTSD or something, that's right, you just got to
or alcohol use
hear their story,
disorder.
or look at them.
Or drug addiction, exactly. So
that's right. You become pretty good at it.
If you can see that and you can see that it's undiagnosed and untreated, talking to them, and I mean, you're not a doctor, or you can do is point people in the right direction.
This is what I'd suggest.
But actively doing that at the earliest possible stage, I cannot emphasize how important that is.
And it's hard in criminal matters because unless it's a straight up plea and everything's been negotiated, it's hard to get them off to see a forensic psychologist because from our perspective, we don't do the therapeutic reports, we do the forensic reports, but they've sort of got to agree with the facts before you send them to the doctors. So send them to the doctor and saying, oh yeah, I've been really sad, I'm at PTSD, but I don't accept I kicked him 3 times the ground.
And then you've got that in the report. That's bad.
Is a useless report. So I will usually recommend, from a practical perspective, recommend someone to say, look, go and get your own therapeutic, go get your mental health plan, they're free. You're going to wait 8 weeks because, you know, let's be fair dinkum. There aren't a lot of psychs around these days, and lots of them looking after people like me that are walking well. But as a result, you may as well get that process going. And don't just talk about the matter, go and try to get the diagnosis. At least do something. And if you can't get in, at least with a mental health plan, we say, look, we're trying.
Yes, exactly.
We're doing it, we're trying.
That's right.
The first attempt wasn't 3 weeks before a sentence, 4 weeks before a sentence. It wasn't we waited 8 months to get the forensic report because we had to do the negotiation of the facts. So there you go.
That's exactly right. And I think understanding as well that if a person's on remand, if they're in the community, once you know that they're going to be into the visa cancellation immigration space post criminal matter, all of their behaviour, everything that happens from then onwards is going to be inspected in detail at the tribunal. Like everything. So the tribunal is going to have access to behavioural reports from how they've behaved in prison. And so you guys having that conversation with your client, that it matters what you do now.
100%.
Really, really matters. This is another reason, which I'll talk about at length shortly, is about getting an early referral to an immigration lawyer so that we can have that conversation with them as well.
And that's the practical stuff I was into with them. But if you're not sure as a criminal lawyer, then just, not that I'm plugging Victoria, but there's one of my few that do it. But in all honesty, get that, what do I need to be looking for?
Yeah, exactly.
I've got a person here who's not an Australian citizen who's in charge of this. What should I be doing that'll make his or her life easier for them? But also too, from the funding, which is a practical perspective, but from the funding perspective, you're going, well, you're going to have to pay for it eventually, team.
Yeah,
so let's just get it done now.
Exactly.
Use it, and then if Victoria needs to get an updated report, well, happy days. You've at least got that connection with the person to say,
100%.
Saw him in 2022, saw him in 2023, my diagnosis hasn't changed. If anything, he's better and got greater insight as the recidivism is even less down than what it was in 2022.
Exactly. So we know that this process is going to take a really long time, and we need to use that time effectively to demonstrate to the department, to demonstrate to the tribunal that there is a progression in terms of rehabilitation if there's an issue, if there's that they're demonstrating consistently
that's right,
that they're able to positively contribute.
But not just that too. Like, I mean, if a client says, look, if I'm going to be deported, should I send my wife and children home now? I'm not answering that question. You talk to immigration because I don't know if that makes it easy for you to keep your visa or makes it harder for you, because I'll say, well, that was simple. You sent your missus and kids home.
Yeah.
No hardship on you. They're back already set up in whatever country it is. That's right.
Yeah, exactly.
And seeing from a risk perspective, you should be getting that advice. It's the same as family court proceedings. Should I be leaving the house? Will that have an impact on my property settlement? I don't know the answer to that. here's some family lawyers, go and speak to them to make a decision.
Exactly. So the next point here is about the agreed statement of facts, which Nick has already sort of alluded to how important getting the client on the same page with the agreed statement of facts. So this, for me, this has been really interesting and a bit of an eye-opener for me.
Yeah.
And there's probably the first part where I started to go, I need to start talking to criminal lawyers about how this works, is because consistently, and obviously this is clients reporting this third hand, so I'm absolutely taking this with a grain of salt. But consistently, I've had clients over the years say to me, I never read my statement of facts, which I don't accept that maybe that's true or not, or they've not paid much attention, or there are things in the statement of facts
that I never agreed with,
that I don't agree with, but I didn't care because, it's just easier. I was told not to argue about it because it could impact.
Well,
maybe it would annoy the judge and...
Look, there are all those considerations. And look, the sentencing process isn't a scientific equation.
No, it's an art.
It's just not. There's a reason why there's people who are good at it, people who are bad at it, and everyone else in between. The reality of it is some of those things are true. I mean, every diligent criminal lawyer who's listening to this would sign their client up to instructions, identify issues in the statement of facts and make sure they've got those instructions, say the reasons why they're pleading and why they're still accepting this stuff.
Sometimes clients are just not engaged in it in a really full way.
But these are the hardest matters because these are some of the matters where you go, look, if there's any further delay, the penalty goes up.
Yes.
And if there isn't, but you may have to accept that you punched the person 4 times, not once.
Yeah.
It won't matter because we've got what they're submitting for is that you shouldn't go to jail.
Yeah.
So that's going to defeat having to get your visa cancelled.
Yeah.
It depends on who walks out that door as to whether or not they're on side. But if we adjourn it for another 6 weeks or set it down for a trial to remove 2 punches to 1, you're waiting another 6 months. So there's all these practical considerations. And I get that some clients don't necessarily understand that once the shock comes in of, oh shit, that didn't work.
Yeah.
And they've gone out the side door. And so they're going, oh, I knew I should have fought that part. And you go, mate, even if you had fought that part, you may be doing 18 months now as opposed to 6. And that's where they become really difficult competing forces.
Well, let me explain before we...
So please.
Sorry, not to interrupt you, but I want to explain why what significance the agreed statement of facts have for the immigration matter. So for immigration matters, and this is less important at the departmental stage, but crucial at the tribunal stage. Because as I've already spoken about in the first half of this CPD, the tribunal stage is the government is represented by a lawyer, the applicant is represented by a lawyer, and there's a tribunal. So there's an adversarial hearing. It's not an inquisitorial type hearing like it is for most immigration matters. So the client is going to have examination in chief. I'm going to ask them a series of questions. Then they're going to be cross-examined by the respondent solicitor. Yeah. Every single time we do the cross-examination happens at the tribunal hearing. Yeah. What happens is that the person is led through the agreed statement of facts and asked, did you do this? Did you do this? Did you do this? And I have... over time, was seeing clients saying, no, I didn't do that. But they've pled guilty to that agreed statement of facts. Yep. And that tension where the client is like, yes, I did agree to that, but I agreed to plead guilty, but I didn't do that. Yep. That just doesn't work at the tribunal stage because partly what it does, it gives an impression that they're trying to minimize what they did. Of course. I mean, they are. Often they are. Yeah. They're trying to minimize what they did. They're trying to downplay it. And it just doesn't come across as remorseful or that they're being accountable or taking responsibility, which is really crucial.
The same reason why they sometimes plead guilty to a statement of facts where it has 3 punches instead of 1, because you're going, it's the same.
Exactly, because it looks like you're...
That's right.
Exactly. Yeah. So we'll talk about it a little bit more in a bit, but I think making sure the client, if you have a visa holding client, that there's a little bit... If you have an Australian client and they plead guilty.
Yeah.
And, there's obviously the discussion about the agreed statement of facts. There's no significance down the line about what's in there.
No, unless beyond some regulatory
Yeah.
APRO, whatever it is.
Sorry, that's
correct.
a really good
Yes.
point. There could be potentially
there
in
could be,
other
but
administrative stuff, but
it doesn't have the same impact as this. No, correct.
exactly.
Yeah.
But if you've got a visa holding client,
Yeah.
you have to know that client is going to be interrogated and cross-examined
Yes.
as to what they did that
Yeah.
day. And if there are not necessarily little bits that are different,
No.
but if there is a significant difference in terms of what they are saying happened, and that sometimes it may be worth
Yes.
doing a
Yeah.
little bit more in
Yeah.
or at least making sure everyone's on the same page about
Yes.
what the agreed statement of facts means for them.
And the difficulty again with that is in an ideal world, we would have a system where you go, this is what we've got at the moment. Please, court, can we adjourn this for 6 weeks so we consider the statement of facts, get advice from the immigration lawyer to make sure that what the ramifications are either way. So we have 6 weeks. But you have a court going, you got to sort it out. Or you've got till tomorrow.
Yeah.
The trial's listed today.
Yeah.
And that's where a lot of this can sometimes turn pear-shaped. A lot of negotiations occur on the day.
Yeah.
It's there, and then you've got a statement of facts, and they go, it started at 7 kicks, it's now 3 kicks. You accepted it was 2 kicks.
Yeah.
What are we going to do?
But if you start with your client with that understanding of
Yeah.
the significance of the statement of facts,
Yeah.
that client has engaged with that prior to that date.
Oh, yeah,
hopefully.
Sometimes.
Sometimes, yeah.
I mean, look. Every client should know the case against them. You know what I mean? Like, good practice dictates you sit down and say, this is what
Of course.
the Cupidines are saying. They go, well, I don't agree with that.
Yeah.
So, okay, but what's it going to mean by way of penalty? Probably not a lot. So you can spend $15,000 going to hearing over that.
Yeah.
You can spend $6,000 trying to negotiate.
Yeah.
$15,000 or $6,000 trying to negotiate.
Yeah.
And there's those practical considerations too that make it difficult to go, there's only something, you know what I mean? In a perfect world, run your trial. But then the risk becomes when you run your trial is it gets worse for you. A magistrate or jury goes, no, you did kick him 8 times.
Yeah.
You go, oh, wow. We had you 3, mate.
Yeah.
We had you 3 kicks. And now you run the risk of getting 8. And your best case scenario in your version is 1 kick or 2 kicks.
Yeah.
Is there much difference between 3 or 4? And maybe that's a sort of, and that's where I think sometimes with the client management to a degree, where they are interrogated like that, you're going, well, look, they understand going, we have to accept 2 or 3, mate. Because remember, we started at 8.
Yeah.
So it got to 2 or 3. And you just have to ask this question, go, I accept I pleaded guilty on that basis.
This is really interesting to me because this is obviously not my expertise in relation to how these things get negotiated. And I think from my perspective, if the client is, like, for example, if you've had that client come and talk to an immigration lawyer early, I'm going to have that, like if I'm speaking to them, I'm having that conversation with them about how important it is that they understand what that agreed statement of facts is.
Yes.
And then that will hopefully focus their attention on engaging with the criminal lawyer properly.
Yeah.
But I don't think this necessarily changes, or I don't think I'm asking necessarily for a change in criminal law strategy around this. It's maybe just to be really a little bit more aware of making sure that the client understands the impact later on.
Look, but even from our perspective, because at the end of the day, and again, this is a very novel thing, the 3 kick, 8 kick, whatever it is. And it doesn't just obviously occur in a vacuum. We don't just get to say, will you accept 3? It'll be from someone else's statement saying, well, this witness said they only saw 3.
Yeah.
He's saying it was 8. My bloke said it's 1. So can we go with the witness who's independent? And then you turn to your client and say, well, they're going to accept the independent witness. Yeah. Okay. And that's it. And that's sort of the understanding, I think. And again, as the diligent solicitors who practice in criminal law do, well, at least I do, and what's the team do, is you always say, go and see them ASAP. Yeah. And that's not washing your hands of the situation. No. But when it comes to census time, you go, what does your migration lawyer say about all this? Oh, I haven't spoken with them. Mate, I told you 6 months ago to do it. What are we doing today? Yeah. And that way, at least, if it does become an issue, you say, mate, we've always given that advice. We've standard letter, we've got all this. And say, mate, we've done what needs to be done. Because a lot of them, at least again anecdotally, the visa's a secondary issue to them. It's, I've got to stay out of jail or are you going to get me under 12 months? Yeah. Yeah, potentially. But you got to remember, it's not actually serving 12 months. It's just being that sentence of 12 months.
Yes, exactly.
And that's the difficulty, or the cumulative nature of we've already had 3 months up your sleeve before we've actually got 9 to play with. So I find, at least with the mindset of the accused, it's always about trying to stay out of jail as opposed to, because mate, if I go to jail, I'm losing everything anyway. And they realise they're not going to lose everything anyway because it's only 8 weeks in jail.
Yeah, exactly.
And they do lose everything anyway because the wife and kids have had to go back to, whatever country it is.
But this is, I think this is why the sort of cooperation between immigration laws and criminal laws is so important, is because these conversations have really informed my immigration practice. And I can see that, when I've got early engagement with criminal lawyers, which I do very regularly, it just means that the services that you guys are providing to your visa holding clients are, the kind of the best level of criminal law service,
100%,
basically. The other thing I would just say on this point is it's not necessarily about the elements of the crime either.
No.
So what I have very commonly seen in statement of facts is extraneous circumstances that don't go to that the person's not being charged with at all. Like, that doesn't form part of what their charge is.
No.
But it's thrown in there
as
sort of the context or the sort of surrounding stuff. The client disagrees that it ever happened.
Yes.
But because it doesn't form the element of the crime, then sometimes the criminal lawyer hasn't bothered to...
Well, in a classic example of that is where a statement of fact says it was an unprovoked attack. They go, well, actually, it wasn't unprovoked. Who called me this?
Yeah.
And then you go, but you pleaded on the basis that provocative, that your action was disproportionate to the provocative action. So, again, and this is why I find quite interesting sometimes too for immigration stuff, that's often addressed in submissions.
Yeah.
It may be in the schedule of facts, and you go, look, we accept that schedule of facts. We accept outside that hotel on that night we did these 3 kicks.
Yeah.
Well, then, now you're saying the tribunal was provocative. Yeah, well, my barrister said that as well. My solicitor said that. Because you can still plead guilty on a statement of facts, but still, it doesn't necessarily, not everything is contained in that document. Now, sometimes you don't get the opportunity when you're on your feet to say it, because sometimes, the judicial officer might intervene and go, look, I've made up my decision.
Interrupt you.
It doesn't worry me what was said or wasn't said beforehand. You can stop talking about that now. He kicked the bloke on the ground 3 times. He's going to jail for 6 months.
Yeah.
And so sometimes it doesn't come out for that reason. But you also can't include that in a statement of facts because from the prosecutor's perspective, well, that's not part of the facts. That's part of submissions.
Yeah.
And we may disagree with that. We may not be able to negative that was said, but we're not going to put in our statement of facts because none of our witnesses heard it. You want to say it, knock yourself out, but we can't negative it.
And so just to explain what can happen then is then at the tribunal stage, those extraneous matters, if they're part of the agreed statement of facts, will be taken as that occurred.
Yes, that's right, yes. Yeah.
If you've pled guilty to that, so
right.
you're agreeing that occurred. And then that can, because it's not a criminal law matter, this is a civil law matter.
Yeah.
And they basically will say, well, you did that, and that's terrible. That looks way worse. And it makes it more likely that the decision will be negative.
Exactly.
So I don't have great answers for how to deal with that. And I do think the risk of just putting it in submissions is that you may not get to say it, or it doesn't get reflected in the sentencing transcript. But
the issue is if you can't get in the schedule of facts, then you go to trial. Because a prosecutor is not obliged to put our version in the schedule of facts.
No, of course.
You know what I mean? So the prosecutor goes, I'm not putting that in there.
Yeah.
If you want to have a hearing over it, knock yourself out. And that's when you turn to your client and go, you want to have a hearing. And sometimes what the client's saying, if there weren't any witnesses to what they heard them say, hey, you're not going to win that hearing anyway because there's 6 of them and 1 of you and no one else heard them say to you this. So are we really going to have a blue over this?
Yeah.
Or are we going to try to keep out of jail today?
Yeah.
As colloquial or as anecdotal as that is, but that's sometimes how it is where you're going, in a perfect world, you would be able to say with the prosecutor, now look, what we say occurred was all this and we want you to tell us in. You go, well, I don't care what he said half hour before. That's our statement of facts. Our statement of facts is he kicked him on the ground.
Yeah. So obviously, I think you can see there's not a single answer to this. No. I think if all I could ask is just to be cognizant of it, be aware of it. And
you are, when you know it, prudence solicitors should be aware of a criminal practitioner and should be trying to address as much as possible. And we do, and that's why when we find out at the bar table that they're in fact not an Australian
and
citizen.
Then you're like, oh no.
An Australian citizen, you go, but I asked you 7 times or twice, you know what I mean?
Yeah.
You got to do a lot of fancy footwork, but there's always abdi in the cases that you can then, that have a seasoned solicitor should know to be able to at least throw in what's sort of necessary.
I also think that because I'm aware that, trying to haggle over some of the details that don't seem that important.
The minutiae
that if it gives a negative impression of the person, it will 100% matter at the tribunal stage. And I don't, in terms of how that negotiation happens with the DPP, etc., if you're making it clear to them that we wouldn't normally be bothering about this, but this person has a visa, and there's going to be implications. So if there's something that a client's really adamant didn't happen, this is explaining to them why that you're arguing so that you can give context to that rather than just pure recalcitrance.
Look, I agree. And the only hurdle, well, not the only hurdle, one of the hurdles there is that you're fighting against the delay clock. You're fighting against the clock of a court saying, well, you either did it or you didn't. Because if you didn't do it, have a trial. If you did do it, why isn't he pleading? So you're also facing this nature of statistics of having to get matters sorted.
Yeah.
And that's the conversation you have with the client. So, look, mate, we're going to journey again for the 6 weeks to the submission. But that's a further 6 week delay if it's not. And at the moment, we're on razor's edge about going to jail or not going to jail. Do we delay it further, or do we do it now? Now, obviously, you're never going to get someone to plead guilty to something. So what we're talking about here isn't necessarily someone going, did he do it or didn't he do it?
No.
It's sometimes the factual basis of, was that provocative comment enough for you to actually have a defence of provocation? No, it's not.
Yeah.
Okay? Because it's disproportionate what you've done.
Yeah.
Go to trial if you want, knock yourself out. But if not, then we have to deal with that. But you've always got the ticking clock on the background of the court also saying, why did it take 12 months for this to resolve? Your bloke's not remorseful because there's a massive delay. And unless you can show the negotiations served a pretty good impact or changed something significantly, the court goes, this is all delay. It actually undoes what you're trying to do, which is our goal is to keep them out of jail, your goal to keep them in the country.
Yeah. So there's a lot of tension in this stuff, so there's no one perfect answer. But I think if your starting point is being aware, I think that gives you a good place to come from. The next thing to mention is, as you would have seen in the first part of the session, is these clients, once their visa is cancelled, which can happen quite early in the process, once they get released from prison, they're going into immigration detention. A lot of people say, I can get a bridging visa E. No, there's no bridging visas.
Pinkenbar, isn't it?
Yes, they're going to go into Pinkenbar. If you've been cancelled under 501, you will not be in the community during any subsequent process, immigration process. You're going to be in immigration detention. And I'm not afraid to say that immigration detention sucks.
I imagine it's correct.
It's awful. It is not a good place. It's chaotic.
I've never been to good detention.
No. I can't compare to, I've never been to a prison.
No, I just mean detention in general.
Yeah, no, I agree. All detention is bad. But from what I can tell from talking to clients is that prison is very structured and routinized.
Yes.
Immigration detention is not. And so that additional level of freedom...
Like a loose grade 11 camp or something.
Particularly for criminal matters, you're surrounded by people with criminal matters where obviously there can be a very wide range of types of matters.
That's right.
Everyone is extremely distressed because they're all under a huge amount of pressure. Some people have really significant medical issues. They're likely to be removed to countries they've never been to, so very, very high level of personal distress. You're going to have limited medical health care in prison. You get access to Queensland Health, so full psychiatric care, all of that sort of stuff. You're under, absolutely different arrangements at the detention stage. There's limited access to rehabilitation and other therapies, not the sort of very formalised rehab that can happen within prison systems. Obviously not saying prison is one.
Oh, no,
they're both horrible in their own different ways.
Amusement parks, that's right.
No. So often I find clients, I always say to clients, if it was me, and particularly if I was going to be going to a country like New Zealand, for example, I would wait out the process in the community in New Zealand.
100%,
I'm not staying in immigration detention any day longer than I can. Often clients think that will, signify, that will mean they won't win. Like it's impossible to win. That's not true. I win cases where people have been removed to New Zealand. So definitely be aware that immigration detention is not fun.
No, well, it's interesting because a lot of some clients say, should I apply for bail? You're going to be going to immigration detention, and that time doesn't count towards your sentence because you're actually on bail. So you're going to do a pretty ordinary amount of detention, then run the risks of actually coming back into jail. You may as well. As awful as that sounds, someone again who's never actually served a sentence, been to lots of jails, but never actually served a sentence. It's hard thing to say. You may as well just sit it out. Particularly too, if you're looking at the 12-month sort of rule, where you go, well, look, if you stay there for 6 months, we might be able to ask the court to take that 6 months off the head sentence and give you 6 months wholly suspended or something to that effect. So, there's a bit more to play with there, because I think they have this fear of going, well, what if I'm on remand for more than 12 months? If you're on remand for more than 12 months, you're in trouble anyway.
That's bad.
You're looking to sort of charge. But if you're in there for a couple of months, saying that we're going to be having an argument about that 12-month thing, then sometimes there's a benefit of actually doing remand time to be able to say, we've got something we can play with to try to structure a sentence.
That's such a good point, because that really goes to then your legal strategy is to, what the actual end sentence is, which makes a huge difference.
Can you take it off the top? And you can never really, again, say I'm taking it off the top because I want to avoid immigration detention.
No, but
you can. But there's lots of different ways you can structure it once you've done that time. Even if it's just a couple of weeks, it's enough to sort of play around with it. So look, they've had a taste. Let's wholly suspend it after 9 months.
Yeah. I mean, if you've got a client with really significant, like maybe psychotic or schizophrenia,
but that's different issues.
But in that case, the structure of
custody.
It being in prison, where they've got access to Queensland Health and very stable treatment,
100%.
is often going to be preferable to be in immigration detention. Massive change of medical providers.
Yes.
Much less kind of supervisory sort of situations as well. So that's something to keep in mind. Just a quick note about legal representation for Section 501 matters. And obviously, I do this work, so I don't want this to come across as self-serving at all, but there isn't a lot of people who do this work. I am, if there is an immigration lawyer who is listening to this, this is something I am regularly encouraging other immigration lawyers in Queensland to move into. It is, these matters are highly complex, they're really difficult, they're resource heavy. So it's not easy to just pick them up like you might do in other kind of immigration matter. There is limited legal expertise in relation to 501 matters. Yes. There has previously been some really amazing lawyers, but a lot of them have moved on to other areas, sadly, which is a loss for Queensland. There are immigration lawyers interstate who do more regularly do this, particularly in New South Wales and Victoria. So if you're not able to get representation in Queensland, you can look interstate because it is federal law, so that's okay. There isn't currently public funding through Legal Aid Queensland. So, I did mention that before. So once the client moves into the visa cancellation space post criminal conviction, it is going to be fully self-funded. Or will have to be represented pro bono, and there's almost nobody doing pro bono work in this space. So I do it, but it's very limited in terms of my capacity to people with severe disabilities. So the ability to self-fund is going to be really, really important. And often that requires families sort of to contribute to that process. So that also means, if you're referring to an immigration lawyer, making sure you're referring to someone with expertise in this area is really important. All right, so this is we've got a series, I think, of 6 takeaways that we're going to go through for criminal lawyers. And these are meant to be super practical about how to implement this into your practice as a criminal lawyer. And takeaway 1 is obviously identify as early as possible. And Nick, you said this right from the start. Identify as early as possible if a person is a visa holder and whether that visa is temporary or permanent. This is the base. This is the foundation of everything. And
yes or no, Y or N.
Exactly.
One thing: date of birth, address, email address, phone number. Are you an Australian citizen? Yes or no? Circle it.
And you said something really important before. Sometimes clients cannot answer that question accurately for themselves.
Spot on. And I mean, there's only so much cross-examination with your client. You also then sometimes, it's because, in any world, I guess, people may be concerned about asking clients that question and thinking they're being racist or whatever there is. But it's like anything. I just need to ask this question.
It's for the client's benefit.
And so long as the next question, asked, which should also be, do you have any professional bodies that need to be there may be consideration of, do you have a blue card? So it's just general questions.
Yes.
It's just a checklist. You don't even think about when you go to a doctor.
No,
you just fill in it, stick a clipboard on, you go, he'll be out in 5, and you know they're long. He'll be out in 45 minutes. But you just fill the form in. Just ask. It's really simple. Just identify the issue.
Yeah. So just to explain why, because I think people might be listening to this and going, how could someone not know that they're not an Australian citizen?
Well, lots of people don't know. I think they've been here for a long time.
Lots of people.
I've always lived here. Got to get when I was 2.
That's exactly right. So what happens, and this is most common with New Zealand citizens, but it can happen to someone who's from anywhere basically, where a person has come to Australia, particularly as a child, and has lived here their whole life and has never travelled anywhere. That person may assume about themselves or have been told by their family that they're an Australian citizen, but they're not. They might have even been born in Australia. Yeah. And so being born in Australia, they have the idea that, because we're exposed to the US style of things where there's birthright citizenship is not a thing in Australia. Yeah. So whether or not a person is an Australian citizen, that person may not be able to accurately answer that question for you. So let's give the example of a New Zealand citizen. New Zealand citizens on arrival to Australia get something called a subclass 444 special category visa, SCV. That 444 is granted to them on arrival. So it's not like everybody else. It's a very special, unique circumstances where they didn't have to pre-apply for a visa. They come to Australia and on arrival they get granted this visa. This is a temporary visa. It's not a permanent visa. Right, so a lot of New Zealand citizens say, at least, that I'm a permanent resident. Nope, no, you're not a permanent resident. A lot. You're a temporary resident. Yep. It just has a lot of the features that we typically associate with permanent residency. Right. So indefinite right to stay, that they can work full time. They have access to Medicare because we've got reciprocal arrangements. They have some access to Centrelink benefits like disability support pensions because of reciprocal arrangements. So they can be very confused and not understand their own status. Right. So it's not just a matter, and I think you've had a client where you said, are you a citizen? And they said, yes, that person was a New Zealand 444 holder. 100%, that's right, So it's not
but even his wife thought he was.
Yeah.
But that's what I was. Yeah.
They just don't know. And this is the question can't just be, are you a citizen, yes or no? So ask that question. Yeah. That's a good starting question, but you've got to ask a few more questions. So another question will be, where were you born?
Yeah, that's right.
And do you have a passport, an Australian passport? If they say they're a citizen, do they have a passport? And if they don't, if they were, you're wanting to ask more questions. So if a person says they were born in New Zealand and they said they were a citizen, that person you need to make sure that they're in fact a citizen and what process that person went through to gain citizenship. Right. And if you can see that if you ask what process did you go through to gain citizenship and the person can't answer that question, flag with them, we need to make sure you are in fact a citizen. And that requires referral to an immigration lawyer. But you do need to identify that at the client intake stage. So we have a sample intake checklist that my firm has developed that we give to everybody. So that will be available through QLS as well, along with the CPD. So you can adapt that into your practice as a criminal lawyer. And it includes the types of questions that we recommend that you ask your clients at intake. But establishing that right at the start, along with, as you said, blue card, are you a doctor? Do you have APRA?
Exactly.
All of those sort of things, that's going to be relevant.
Yeah, okay.
So you've identified that your client is a visa holder. So I've also said you need to know, are they temporary or permanent?
Yes.
The reason that is significant, we probably will put permanent residents and New Zealand citizen visa holders in one category together. Yeah. And then you put temporary residents. So temporary residents is basically a time-limited residence. So there's things like student visas, visitor visas, work and holiday visas, maybe a 482 employer-sponsored visas. Those are all time-limited. There's anywhere between 6 months to 4 or 5 years. Yeah. The likelihood of success of a temporary resident through a 501 process where they've been convicted of a crime obviously is very low because for obvious reasons. This person doesn't, if you look at what we talked about the exercise of the discretion, all of the factors that make it give the possibility of being successful in these matters don't exist because they've not been here long enough and they just don't
that's right.
have the that permanent right to remain here. So that is really significant. That is going to inform, maybe that person doesn't get referred to an immigration lawyer because they accept that, they're going home and maybe they want to go home.
Well, they want to go home. Most of the student visas I've come across do.
They do. They're like, okay, that's enough of that.
Don't give me community service. I'm happy enough for a suspended sentence.
Yes.
I'm not planning it out here. Yeah, 100%.
But your permanent residents and your New Zealand residents, they're a totally different story. They have a much stronger connection to Australia and they are likely to have much more motivation to want to stay.
Yes.
And so that is really impactful. So that category are the ones that you really want to be, likely referring to an immigration lawyer at an early stage. Okay, so now you've identified you've got a permanent resident or a New Zealand citizen with a criminal charge. You need to understand whether that client is likely to go into a 501 process or, potentially a citizenship revocation process. I won't go into that in too much detail in this session, but it is possible to get citizenship revoked. I have talked about that slightly before. That is a very unusual set of circumstances, but
not impossible.
Not impossible, but we'll certainly focus here on the visa cancellation process. So where this is going to come up, and this is based on the 501 character test, so this is the threshold for exercise that power, is a charge that might result in a head sentence of 12 months or more. And that is whether or not any time is going to be served. It could be a charge that will result in a head sentence of less than 12 months, but where the client has had previous criminal convictions with sentences that adds up to 12 months. So the total period of imprisonment on their record adds up to 12 months or more.
Yes, whether they've been in custody or not.
Exactly.
That's right, yes.
Exactly. If the person has a child sex offence charge, regardless of the likely sentence of imprisonment. The last two on this slide basically relate to some more unique circumstances. So number 4 is the citizenship revocation case. So this is where a client is an Australian citizen.
But prior to becoming a citizen has committed offences but isn't convicted till after citizenship.
Exactly right. So this
had we known at the time, you wouldn't be a citizen.
Exactly. So this mostly comes up for historical criminal matters. So most likely historical child sex offences. So this is where a person the offence was committed, 20 years ago. The person that was not discovered, the person becomes a citizen. And then after becoming a citizen, they get charged and convicted of that historical child sex offence. That person is potentially subject to revocation of citizenship. Once the citizenship is revoked, they'd be subject to visa cancellation. Then you have temporary visa holders who have a charge. That person is going to have an immigration issue that might needs to be addressed in some way. All right. So once you worked out that your particular client, there's a risk of them going into this immigration space. At that point, you really want to consider. All I'm asking is you turn your mind to it. So I can't tell you what this means to you as a criminal lawyer. But what I'm asking is for criminal lawyers to turn your mind to what the consequences of the decisions that you make at that stage that might have. And is there a way of accommodating that? And maybe there's not a way of accommodating
look, there's always a discretion under Section 9 of the Penalties and Sentences Act. The court taking account basically anything. Obviously, there's Abdi's decision, the Court of Appeal, 2016, which talks about it can't overwhelm and there needs to be a certain amount of hardship that comes with that in itself just isn't enough of a fact to, give a sentence of 11 months, for example, as opposed to 12. But there's always ways, not always, there's often ways around that sort of 12-month mark because you're talking about short periods of imprisonment, of actual imprisonment. Violence is always very difficult, obviously, because imprisonment is not a last resort. But if you turn your mind to it and know that's an issue, then it's a lot easier to be able to try to think of something clever. Or structuring of a sentence in such a way. But if you're not alive and go, oh, look, you're not going to jail, they're saying 15 months wholly suspended, but that's going to get me deported. And even though I'm not going to jail, that's going to get me deported.
Exactly.
You also don't want to come along and say, well, look, give us 10 months and we'll serve 3 of it. So there's always something you can do, but it will always, it's something that really doesn't overwhelm too much what you can actually do with the actual penalty ranges. So,
Yeah.
But a classic example was, doing the 4 weeks in custody.
Yeah.
And right, he or she's done their 4 weeks. Would they have done actually 4 weeks for this offending altogether? Probably not of actual imprisonment. So why don't we now look at a community-based order?
Yeah.
Why don't we now look at this? Why don't we now look at it being 6 months or 4 months or 3 months or whatever it is, to say, without even really needing to digress into the migration space, because it's just literally doing the structuring around what's already transpired.
And this is something where, look, no expertise whatsoever.
No.
I don't know what is possible, but if you know that there are potentially negative consequences if certain thresholds are met, how can you creatively, address that in your practice as a criminal lawyer?
And look, and particularly assaults are very difficult because there are certain sentences where you go, and because assaults I should say offences of violence, because imprisonment isn't a last resort for offences of violence, the penalty ranges and the discretions differ so much between the court, the judicial officer, how the prosecutor, and it's not occasionally how we kick, we don't kick someone on the ground. You could get $1,000 fine with no conviction recorded, or you could get 12 months wholly suspended period of imprisonment. It really is.
Yes, and I've seen those.
And it's so dependent upon the extenuating circumstances or the actual physicality behind it all. But it's not uncommon to have such a wide range. And when you do initially see a person, and it probably should make you more alive to say, look, you could get $1,000 fine. You could also get a 12-month. You could go to jail for 3 months. Yeah, it's drunken violence in the valley. Yeah, you could go to jail for 3 months. But I did get someone 100 hours community service that day for the no conviction recorded. Yeah.
But if you're a criminal lawyer going into the matter and you know that there's certain things that
you'd be more alive to.
Exactly.
And you at least better bring that back.
Arguments.
But you'd at least better bring that back to the legal strategy like you're talking about, going, our key goal's got to be keep you out of jail. Yeah. Okay? Or does it have to be, when it comes to migration and stuff too, are you better off doing a month? Yeah. Yes, exactly. Are you better off doing a month now in custody? And saying, look, we accept it's serious. Make it six to do 2 months. Yes. Make it 6 to do 3 months. The head sentence doesn't need to be 12. It's a third bottom. Make it 9 months to do 3. That's always the example I give to clients when I talk to them. And this is an ignorant example from a non-criminal lawyer. But I say, it might seem good to get a 12-month sentence but wholly suspended. No, that's right. But it's not better in your case. In your case, you'd be better off getting a 6-month sentence and serve 3 months. Exactly. And we say that all the time when it comes to certain sentences. They say, ask the judge to keep me out of custody. And you go, look, this judge might keep me out of custody, but the Crown will appeal it. And if they appeal it, they'll get there 6 months. If we say now 1 to 2 months is about right, you're avoiding the 6 months. Yes, exactly. Well, how do you know it's going to happen? His experience teaches that. It's happened so many times. This is the art. This is why we're telling you not to do it, because the last 3 went, that was 100% strike rate. So, but in all honesty, it is one of those things that, again, can't overwhelm the court, but it is something you can apply to strategy without necessarily being, a manipulative way of trying to get around it. Because it's not a manipulative way of trying to get around it. You just
you're serving your client's interests.
Saying 100%.
That's
exactly it.
And that's what we're here for, right? Is to serve our client's best interests. So the questions I've asked on the screen here, so there's a few pages of this. So if the client is pleading guilty, what is the best outcome for that client in terms of sentence? And so you're trying to avoid key risk points. So
that's the 12 months.
The 12 months or adding up to 12 months. Or
child sex
a conviction for a child sex offence. And if you've been charged with a child sex offence, then you might get a conviction for a child sex offence.
Oh, well, you will.
Yes.
You have to go to jail except in exceptional circumstances. Yeah. So on a child sex offence, you'd probably just have to run a trial. Yeah. Plead not guilty. Yes. And if there is... If your primary concern is that, Exactly. And if you deny it, then you should make the effort. Yeah. Exactly. Agreed. That's the kind of first question is, what are your key risk points in terms of sentence in the visa cancellation space? The next thing is something we've already talked about at length, so we don't need to talk about this again in much detail, but the agreed statement of facts is going to be critical at the 501 process. And
client will, it has come up
so
more
times.
than once.
Oh, yeah.
The client will has pled guilty and then will tell me at the my stage, at the immigration stage, that's not what I did.
That's no. Well, the one I always get is that's not what happened.
Yes, exactly.
That's not what I did.
That's not exactly
what happened. They didn't mention there that he came and spat on my brother in the beer garden 7 hours before. No, they didn't, mate.
Yeah, exactly. So all I've said here is if the person is pleading guilty, and I'm sure all the good criminal lawyers will already do this, but just emphasize with the client the importance that they actually read the agreed statement of facts and that it is entirely true and correct, and that with all the caveats we talked about before.
That's right. Or if it's not, to do, I think the case is the Myers plan. So I'm pleading guilty on this schedule of facts as per this, and it's acknowledgement that will be a plea of guilty to that facts. Yeah, the track.
Exactly.
You signed it. That's right.
So in talking to other criminal lawyers, and I'd like to hear your thoughts about this, in terms of negotiating facts where there is something in that proposed agreed statement of facts that the client says isn't what happened. If you're going to seek to negotiate that, we know that you don't want to make things worse through that negotiation. But if there is something that has significance in the immigration matter, and you can know this if you've engaged with the immigration lawyer early. So if I've had criminal lawyers come to me with, this is the agreed statement of facts that we're going to be pleading guilty to. Is there anything in here that you think is of concern?
This is what the instructions are.
Yeah, exactly. And I will always say, well, if that's what everyone agrees to, then that's what happened. But this part of it, I think, is particularly going to be taken very badly. So is this exactly what happened, etc. If there is something and you want to negotiate it, potentially what you can do is if you do that negotiation in a formal way, that allows me to cite that in evidence at the 501 stage.
Yes.
So you can eventually give up because you don't want to impact the eventual sentence. So you don't have to spend too long. No. But if you can make it clear that you objected to...
That you attempted to negotiate it.
That you attempted to but made decisions through, sound legal strategy to not continue that. The client I then have more of a capacity at the tribunal stage to say, yes, the client agrees that the elements of the facts that are in here are correct. Yep. There are elements of this that he believes does not reflect exactly what happened.
What transpired. But
we attempted, the criminal lawyer attempted to negotiate that, but a decision was made that in the end, because the elements are correct, not to pursue that. And that gives me something that I can put forward to the tribunal member. So the client doesn't look like they're trying to have their cake and eat it too.
No, and look, and again, without banging my drum about it again, but even with that schedule of facts, there's usually subjective reason as to why it's not in there, if that makes sense. You know what I mean? Like, it isn't like we just pluck it up and go, all right, you remove this, I remove that, you do that. That is part of the process. We go, well, look, there's no evidence other than the complainant saying this. He says he said that, but the two other witnesses don't mention anything about it. So it can't just go away. And usually it will, and this is the whole part with the negotiations. Usually it will. It's usually, well, again, anecdotally, what I find is that it's in fact the instructions the client gives that's not supported by the evidence. You go, you're going to have the same problem with the tribunal. Of course, it's not supported by the evidence. You can keep saying, he spat on your brother at the beer garden 7 hours ago, but your brother doesn't give that statement, and it's on the brief.
Yes.
So
it's not on the CCTV.
It's on the CCTV. It's in no tribunal is going to be accepted on the balance of probabilities, let alone on our test. So
exactly.
You can have a contest over it, or we're just going to go through the keeper and go, which again I would imagine is part of which is part of the migration space too, is exactly the same in the sentencing space, is remorse. Yes. I've cooperated with the procedure. I'm really sorry I kicked him 3 times in the head, as opposed to going, it was only twice. It's because he said someone on Mrs. 7 hours ago.
That doesn't help you. Right. That's exactly right. And that comes across as so like that you're not remorseful at all. And
well, you should have said what he said to me.
Exactly. That you're nitpicking.
There is no evidence he said anything to you, but I know he did, and my lawyers told me not to take issue with it. I could have won that. You're going to lose it.
Yeah. So there's I completely agree with you. And there's a difference between that kind of situation, and sometimes I do see things where you're like, well, if that's true, then why haven't you been charged with that?
100%.
That is a crime too. But you're not being charged with that, so there can't be evidence of that. but it somehow has got its way into the agreed statement of facts.
Yeah.
That type of scenario,
Yeah.
that please make an effort to
Yeah.
because that shouldn't be in there.
No. I mean, in the end of the day, people plead guilty all the time where they don't necessarily get the shit of facts. Not that pleading guilty isn't appropriate, because sometimes the facts are just what the facts are. But you're just saying he or she pleaded guilty at an early stage. It's indicative of remorse. They're very remorseful for what transpired over the incident.
Exactly.
So when the tribunal went, do you plead guilty to the facts? Yes, I did. And you agree with the facts? That's why I pleaded guilty, because I'm very remorseful for what I did.
Yeah.
Because you still kicked the person twice.
Exactly.
It's still a bad incident. There's still someone with significant injuries to their face.
And that's
You're
not
remorseful.
in question.
No. And I'm really remorseful because I don't usually drink piss. And I've upset my missus, and I've upset my kids. I've done this, that, and the other.
Yeah, there's all these consequences, and I'm really sorry
for one
about
really
that.
bad night at the grog.
Yeah.
As opposed to fighting over who did or didn't say something to you 3 hours before.
Exactly. The other thing I just wanted to very briefly mention is I have come across, very rarely, but it has happened, more unusual types of pleas. So pleas of convenience, like a Meisner plea.
Yes, that's right. There's some days ago. Yeah.
That was something completely new to me.
Yeah.
I didn't know that was a thing. Can you tell us what a Meisner plea is? I'm sure our audience knows this, but I certainly didn't know this.
It's the case of the Queen versus Meisner. I can't remember the year, but and I can't remember the spelling. I'm pretty sure it's MEISSNEER.
I think that's right.
Maybe Z's, I can't remember. But essentially, you can accept a plea on whatever version.
It's a plea of convenience.
Plea of convenience, essentially,
Yeah.
Come and say, I'm just pleading guilty.
I'm pleading guilty, but I'm not actually saying that I did all these things.
Yeah.
Now, I've had a case where that has been part of the process. The legal strategy, the criminal legal strategy that underpinned that, I can't comment on it. That's outside of my scope for sure. Look, but I can tell you it wasn't helpful at the tribunal stage.
No, of course not. And look, I can count on one hand the amount I've had to consider in 25 years.
Yeah, it's not common.
No. And look, to be honest with you, it's really uncommon, because usually there's a stack of evidence where you go, well, I'm just pleading guilty because I don't want to plead guilty. But there's also a stack of evidence against you.
Yeah, exactly.
It's not necessarily a Meisner.
And if you really don't think you did it, then you should plead not guilty and go to trial.
Yeah, that's right. People can plead guilty for a variety of reasons, basically. Meisner says it's not enough now to turn around and say, I didn't do it, I didn't do whatever. Once the interlocutor is administered, it's as good as done.
Yeah.
So, and again, I have had a lot of clients in the appeal space to go, I just pleaded guilty on. And that's what it's really to stop. My lawyer never told me anything, but you're found with the drugs in your back.
That's
exactly not a Meisner plea. That's just an overwhelming case that you decide to plead guilty to on sound advice that running to trial would get you double the time.
No, Meisner plea is very formal. Yes. It's part of the
exactly. That's right. Yeah.
Stuff. But from an immigration perspective, it made my life very difficult.
Oh yeah,
because this client, if you go to trial and you say not guilty, you're at least your story is consistent all the way through.
Yes. Yeah.
If you plead guilty properly, then you're saying it happened, and then I can demonstrate remorse.
Yes.
This is somewhere in between those two things.
And look, I couldn't think of any reason why, particularly in this space, you would do that. Do a Meisner and then worry about your cancellation, because it just doesn't seem to make... Like they use you for pretty significant offences as opposed to something that's going to get you less than 12 months.
Yeah.
So,
I mean, that's a client who has come to me after the convictions already occurred.
Yeah.
So I didn't have the opportunity.
No, great. Yeah. I was just trying to even think about why someone would do a Meisner for something that look at less than 12.
Yeah.
Or that wasn't the majority of them are child sex offences anyway. But the Meisner going, well, I can't. I'm just pleading. I didn't do it, and I don't want the kids to. I don't want the kids to have to give evidence.
That's exactly
They're my
right.
grandkids, but I'm not accepting that I did this. Fair enough.
That actually makes sense, that why this exists and why people might want to use it.
Yes.
But in the context where there'll be a visa cancellation process that ensues, it will make the matter really complex. So that might be a conversation if you've got a situation like that making sure you get immigration advice, which you'll see is what I come back to a lot.
Exactly.
So agreed statement of facts. The next other, in terms of considering criminal legal strategy, is making representations during sentencing about the potential impact or the likely impact of the 501 process. On this point, not just about the client.
No.
But more importantly,
family members.
The impact on family members. So this is one of the most heartbreaking things of these processes, is that the 501 process never just affects the person.
No.
Whereas criminal charge and conviction is serving a sentence, it's that person
Yes.
serving the sentence. Obviously, that has impact on the family, of course.
Yes.
But if you've got a client, let's say a New Zealand visa holder, who has a wife, children, all in the community, their visa they go to prison, they serve their sentence, they get released, their visa's cancelled. It's not just that person who's been removed from Australia.
It's the 6-year-old who's
It's the 6-year-old from their friends, the 15-year-olds who
that's right.
loses their not just their friends, their extended family to have to move overseas with their family member. That
Well, they've never
comes up-
been.
Exactly.
That's right.
Over and over again. It's the wife who has gone through the trauma of the criminal process, been, a single mum for that whole period while they're in prison, and now has to leave their entire life behind because of this process. So making representations during sentencing is so, so important.
100%.
Nick's already mentioned some of the case law that supports you doing this. This is, I think I've made a reference to R versus UE Philippides.
Yeah, that's Justice Philippides, Justice of Appeal for Time.
But is it,
the UE, but the main one obviously is Abdi. I do have it here, as you can see from the camera. 2006.
So organised.
Yeah, I know. The first case I looked at. My staff watching this, we go, what's he done? I don't recall printing that out for him. RB Abdi 2016 QCA 98. But that's essentially the case you need to refer to when it comes to these sorts of matters. I mean, the court can't be overwhelmed, but it's still practical considerations in relation to the hardship of it. I mean, look, in a long, long time ago, people did used to impose sentences of 11 months and 10 days. And
they're not going to do that nowadays.
They're just not going to do it. Yeah. And nor should they. But certainly, I think it's very hard to say. I think there's a misunderstanding in relation to the hardship provisions by both defence, prosecution and the bench sometimes in relation to just how significant they really are. Because a lot of, wow, he shouldn't have done that. We accept he shouldn't have done that, but the 13-year-old daughter didn't do that.
Exactly.
The 11-year-old son didn't do that. The wife didn't do that. So that is going to be a significant hardship to these people. Also, too, the rehabilitation process. They've set up with rehabilitation here. Upon release from custody, they've got a psychologist they've seen for 3 years. They've got this, they've got that. If they sit in immigration detention fighting it, they won't be able to see the psychologist.
Yep.
And then their kids are still stuck in limbo land, so they're going home anyway. You might as well go home.
Yeah.
And
the person,
but that's the hardship that I don't think quite always correlates or is taken into account at the time of sentencing. Going, it's not Abby's fault. The dad did this.
The focus is when I see sentencing submissions, but the transcripts, I rarely see mention of the impact on the family, and that is so crucial.
There's a mortgage.
Like
they're not going to pay the mortgage while they're overseas. They're going to sell a house.
So either they move, they get deported as well. Pretty much.
Essentially,
they're being removed as well, or they get permanently separated from their parent.
Yes.
Or husband.
That's right.
And either situation, that's a super hardship that I think is relevant here. It's also relevant which country the person's going to. So there's a big difference between New Zealand and.
Well, that was one of the distinguishing features, obviously, in Abdi going, well, it's only New Zealand. I mean, it wasn't quite as anecdotal cavalier as that. Like, I go skiing there twice a year. Like, aren't they lucky they get to ski all year long? But
and a single guy having to move to New Zealand where he's lived in New Zealand most of his life, that is less of a hardship.
But someone's lived here forever.
Exactly, but it's a big hardship moving an entire family.
To Scotland.
Or
Ireland.
Afghanistan, for example.
Oh, well, I guess. I didn't realize we were going to that. I just were randomly naming countries.
Look, New Zealand is a very similar country, but it's still a hardship to move the rest of the family because, just because you can easily pop back and forth, it's 4 hours flight. There's a difference between living next door to grandma and then seeing her once every 6 months.
And again, there's a massive difference between coming over here on a humanitarian visa or something and then being told you're going back to a country where they'll kill you.
Yeah, exactly. Going back to like Somalia or Afghanistan, these are countries, particularly if they've got any kind of vulnerability, they're going to be extremely at risk. So all of those things are relevant. There is case law to support criminal lawyers making submissions to do right by the client. I think is absolutely 100%. Required, I think, at the criminal law stage. So takeaway 4, We've said this a few times.
Back to Lent marketing. Back to Lenten marketing.
marketing.
Cheaper than the Google.
Yeah, well, yes.
No, but it is true. So I won't let you self-promote here.
Thank you. I appreciate it if you.
But in all honesty, it makes a massive difference having that consultation throughout the process, and also being explained to the client why it's so important in relation to why these steps are being taken, and also to at least, in some situations, and again, look, there aren't a lot of matters that you come across. I mean, there's probably more than you know. There's probably more that happen after you finish around and going, what happened to that bloke? Oh, he got deported or whatever there is. But having that discussion also too, so there's clarity in relation to when it gets to tribunal, hey, Victoria was part of that process. She knew why we settled for this. So don't sit there and say, now, my lawyer didn't tell me to do it.
Exactly.
You guys need to work out your strategies. What you're going to say when you ask that question. Not putting words in your mouth. But what are you going to say when you ask that question about, do you accept the statement of facts? Yes, I did accept the statement of facts. I said that's what I did. I'm very remorseful for what I did.
Exactly. And so it gives a sort of seamlessness through the whole process, so that by the time I'm at the departmental and tribunal stage, where everything has been moving towards giving them the best possible opportunity of success, which, as we said from the start, is hard.
One of the hardest things you can do is cross-examine a truthful person.
Exactly.
Don't I?
No, exactly. And if you can cultivate a relationship as a criminal lawyer with an immigration lawyer, lawyer law firm that does this stuff regularly, I'm always plugging myself, but
you'll get heaps of emails.
No, but people, I'm really happy to have a chat with people about things. I'm always happy to do that. Generally what I would do, and so every immigration lawyer is going to be different in how they do it. If you refer a client to me, I'm going to do an initial paid consultation with them. I'm going to find out what are the circumstances of their case. Hopefully this is before they've got conviction.
Yes.
So that I'm able to input at that early stage, at least so the client understands what is likely to happen post-conviction. So that way your client is going to be completely across the implications of everything. They're going to be very focused on what they need to do. They're going to be better engaged with you as a lawyer. You've also, made sure that they're getting, a really complete, proper legal advice. I'm going to do a paid consultation, that initial stage. Then you can check in with me at various stages on the way. There's no additional cost for that. And then at some point in the future, I will get on the record for the visa cancellation matter. And there's a seamlessness to that, so that I'm well aware of the case well before, years before, is actually at the important point.
That's right.
And that gives us the ability to, make suggestions about, is there evidence that can be collected at the early stage? Is there rehabilitation stuff that can happen? It gives me the opportunity to talk to the client to make sure that they understand that their behaviour is on display and will be taken into account at the tribunal stage. Their behaviour in prison, their behaviour in immigration detention, their behaviour in the community, what rehabilitation they're doing. And we can start all of that process as early as possible. So I already talked about at the beginning that the tight timeframes around at the end of the process. So getting people involved at an immigration lawyer at the earliest stage is so important. Takeaway 5, again, this is something we talked about before, but consider the future visa cancellation process in the criminal phase as you gather your supporting evidence. So particularly around psychological reports. We talked about this at length, so I won't go into it again. But just another reminder that particularly if you've got illegal aid funded cases, if it's appropriate to do so, to use funding for things that are going to benefit the sentencing process that might also benefit the immigration process. And the last takeaway is to just be mindful, particularly if you do legal aid work, because this is more likely where this is going to come in. This process in its entirety, and this is both the criminal justice system as well as the immigration process, has a disproportionate impact on highly vulnerable clients. So what I mean by highly vulnerable is people with severe mental illness, disabilities, cognitive impairment, children, non-English speakers, people with refugee or trauma-related background, who aren't educated, all of those things. So people in that position, this process it's incredibly difficult. And in terms of things like, if a client has never been fully diagnosed, please use the criminal phase as an opportunity to address that. If you can,
right.
obviously.
But that's right. Yeah. Yeah.
Think about legal capacity issues. I can't tell you how many times I've had a client where I'm like, this client has no capacity to give instructions, but a public guardian's never been appointed and they've gone through the criminal stage.
Look, that's really
not to be critical about that,
that's a completely different topic. That one.
Yeah,
it's very, very, very
And I'm also well aware that the legal test for that is complex, super complex, and
the court will be clogged.
Yeah. Exactly. So
if we joined everything for that reason.
Yeah. Don't.
No. I get what you're saying.
Not trying to be critical about.
No. Not. I wasn't saying you were. But I think there's highly vulnerable or completely misrepresented.
Yeah.
Or except she highly misrepresented or forgotten about in the criminal justice system.
I think we're on exactly the same page for that. It's also about access to legal representation, because people in this group are going to be so much less able to advocate for themselves, to pull together the kinds of evidence that's needed. To give you an example, one of the critical steps is to actually request revocation after a mandatory visa cancellation under Section 501(3)(a).
Yeah.
So the person gets cancelled, they're in prison when that cancellation happens. The prison hands them the visa cancellation notice, and the notice says you've got 28 days to request revocation. If you don't request in that time frame, there is nothing that can be done. That person is
gone.
You can't do anything.
No.
And it has happened more than once. They've given that to people with schizophrenia who don't speak English, who don't read and write English, and that person hasn't done it.
No.
And there has been court cases which have, the law I think has moved on from that a little bit now, but it is incredibly difficult to get that undone.
Yeah.
So incredibly, incredibly important that they have early access to legal representation. The other thing to mention is and this is a more recent change from the High Court case of NZYQ a few years ago, which was about the end of indefinite immigration detention for people who are owed protection obligations in Australia. It used to be that people could be in detention indefinitely.
Definitely, yes.
So, and typically that's people with refugee backgrounds who have criminal records.
Yeah.
It's that category of person who was in detention indefinitely.
Yeah.
Now they've been released into the community on something called a removing pending bridging visa, or a bridging visa R. The problem with the bridging visa R, though, is that they're in the community. Great, that's nice, but unlike when they had a permanent visa and they could access NDIS.
Yes, that's right.
And, all of those Centrelink, all of that stuff, they don't have access to that. So most importantly, NDIS. So they're in the community. They might have something like schizophrenia or other kind of severe cognitive impairment, etc., but they'll never get access to that. So they're a huge burden on the state health authorities, and a risk to the community because they're not getting the right level of support. So it's a huge problem. So this whole process disproportionately impacts highly vulnerable people. So
perfect.
That is the end of this session.
Excellent.
Thank you so much for having this conversation.
That was great,
with me.
Victoria. No, thank you.
I really appreciate it.
Everyone listening at home surely got something beneficial out of it.
I hope so. And
please sick and tired of hearing my voice. That's right. That happens in the big jobs.
I have a lot of respect for criminal lawyers, having done this work for many years now, and it's challenging work.
It is.
And
a lot of variables.
A huge number of variables. And there's obviously, as I think we've talked about, this is an art, both being a criminal lawyer and being an immigration lawyer.
That's exactly it. Advocacy is agreed. No, well, thank you.
So increasing our understanding of the kind of the areas of law that touch our own area of law, I think, is really important.
Where they intersect. Great.
I'm always really happy to have a chat with anybody. If they've got a question, just send me an email. I think my contact details are there. But thank you.
Thanks, everyone. Cheers. Thank you very much.
Thank you.